4 ways that you can avoid probate without a trust. What's up, everybody? My name's Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. Before we get to that question of the day, if you have estate planning and probate questions and you would like to speak to an attorney for free, you can go to keylawllc.com. We have a calendar right there. You can set up a time, and we can talk about what your goals are, what issues you're facing, and see how we might be able to help you solve them or reach them. Again, keylawllc.com. Now, on with the question of the day. 4 ways that you can avoid probate without using a trust. First of all, what is probate? It's kind of an important question. We actually have a video on that. If you didn't watch the video, what are you doing? Shame on you. You should go back and watch it. But the TLDR version is that probate is nothing more than transferring your assets to someone else. It typically will go through a court process, which is called probate, but that is a process that transfers your assets to someone else. That's really all it is. Why do we want to avoid it? Well, for 2 reasons. First of all, it can be kind of a lengthy process. In the state of Alabama, the bare minimum is right about 6 months, but it can take years depending on the complexity of the estate and the issues involved and the amount of properties and assets involved. So something to kind of keep in mind there. Those are the 2 reasons why we want to avoid them. So what are the 4 ways that we can avoid that? First one is you have transfer on death or payable on death designations. These are really, really great tools. So basically, you could go into the bank and you get your bank account and you could say, hey, I'd like to set up a payable on death designation for my account. And you can set that up, and basically when you pass on, it'll go whoever that designee is, it'll pay it right out to them. It avoids probate. It doesn't come into your estate. It goes right to them on death. That's one of a really good useful tool along with transfer on death. I kind of group these together because they're very, very similar. Transfer on death is basically a deed that you have that transfers the property upon your death to whomever you designate. And probates are typically initiated when you're trying to change the name on a deed or titles or things of this. So this is a nice little tool that if you have a small little bit or a couple little properties, you can automatically go ahead and do that. So really, really nice there. The second way, and I think is something that's really, really important, is beneficiary designations. We're getting towards the end of the year here of 2023. Lots of benefit packets are going out about health insurance, retirements, all different kinds of things. So this is a great time to make sure that your beneficiary designations are up to date. They're who you want them to be, where you want them to go, the right allocations. This is really, really important. If you are going through a divorce or are about to be divorced, this is one of the first things you're probably going to want to go ahead and update in that process at some point to make sure that you are sending those assets and those accounts to the right people that you choose. Something to just kind of keep in mind. But those beneficiary designations make sure, kind of like a payable on death, it goes to the designee and it doesn't have to come through probate or a will or anything else. So really, really nice tool there. Third, you have joint tenancy with right of survivorship. You'll see this typically when couples buy a home. In some states, you're able to go ahead and set that up where joint tenancy with right of survivorship is on the deed. And what that says is that if one spouse unfortunately passes away, it automatically, their interest automatically transfers over to the other spouse so that they can actually own it in full. So it's a really nice designation. It keeps the property out of probate as it just automatically switches over upon death. Again, it's not for the general public as a whole. You'll typically see that with married couples in states. It's a nice little tool if you're buying properties. I do not recommend if you're writing deeds or doing things on your own that you do it. I would highly recommend that you contact a local attorney in your state to make sure that you can get the correct language, because the language has to be correct for that type of designation and that type of title holding for it to automatically switch over. Again, typically something you'll see with couples. And then fourth, a strategy that is available to you, but not really one of my favorites, is gifting. If you have a large estate, a gifting strategy can be very, very helpful to you. You just give your property away while you're alive. But I'm not a big fan of it for two reasons. First of all, you got to make sure that you no longer need it. There's not an opportunity for you to pick up the phone and go, hey, you know that piece of property that I gave you? Yeah, I'm going to need that back. If you could go ahead and just switch that back over to me, I'd really appreciate it. That's not something that you can really necessarily do without having a lot of strenuous heartache and complications. So that's the first thing, is you really have to make sure that you no longer need the property. You're not going to be using it during your life. And then the second thing is when you gift it during your life, you lose what's called the stepped-up basis in the property. Stepped-up basis basically says that when you transfer a property to a beneficiary, that beneficiary gets the value of what it would be sold for. So if they sell a house for $200,000, the tax basis is $200,000, and there's no taxable gain there for them to be taxed on. You basically get it stepped up to what it would sell for, or what its value is at that time. So gifting is not one of my favorites, but it is another strategy that's available to you. So those are the four ways that you have. You have transfer on death, payable on death. You have beneficiary designations, joint tenancy with right of survivorship, and gifting. So those are the four ways. If you have questions about estate planning or probate and would like to speak to an attorney for free, you can go to keylawllc.com and set up your own strategy session. Again, my name is Josh Key. I'm the managing attorney of Key Law. We take the headache out of estate planning and probate so you can focus on what's important. Have a good day.